करियो ये शेयर आ रहा है ਇਹਦਾ ਲਿੰਕ ਸ਼ੇਅਰ ਕਰ ਰਹਾ वहाँ पे थोड़ा ध्यान से
What is this? We should I think.
Good morning, ladies and gentlemen, my dear fellow mates.
And our esteemed guest for the day.
I am Navpreet Singh.
And I am Arushi Gupta, your host for today.
Welcome everybody to our today's conference on forensic medicine. We would like to extend a warm welcome to our today's esteemed guests.
Dr. R.K. Goria, Executive Director at Medico Legal Institute, Punjab, Registrar, Baba Farid University of Health Sciences, Faridkot, Punjab, and founder of Society for Prevention of Injuries and Corporal Punishment, that is SPIC.
We have amongst us Honorable Dr. Pradeep Singh, the Professor and Head of Pandit Jawaharlal Nehru Government Medical College, Chamba, and General Secretary for Society for Prevention of Injuries and Corporal Punishment, SPIC, amongst us.
Dr. Yadukul Sir, Deputy Medical Superintendent, AIMS, Hyderabad, Associate Professor, Department of Forensic Medicine and Toxicology, AIMS, Hyderabad, Co-Editor of Journal of South India Medical Legal Association, J. Simla.
We are honored to have Dr. Akhilesh Pathak, Dean of Dean for AIMS, Bathinda, and Professor and HOD for Department of Forensic Medicine, Bathinda. A big hand for our honorable guest, please. From Adesh University, we have our honorable guest for the day today. Our Professor of AIMS are Dr. Pramod Goyal. A big hand for him, please. And Dr. Varun Mohan Malhotra, Acting Registrar, Adesh University. Once again, a warm good morning to everybody. Let's begin with our today's conference. India. It's an ages-old civilization which had its interest not only in art and culture, but we were equally interested and were shining in the fields which were away from these classical, what we call images that we have in India. We were equally shining in legislation and law. How so? From the ages-old text of India, we have Manusmriti, the very first text from India which told us about legislation and law. We have the greatest teachers in India like Pandit Chanakya. He is known to be the greatest of the authors of India to write upon law and legislature. He gave us Arthashastra and Niti Shastra.
Arthashastra and Niti Shastra? That's all I could catch. What is that?
Arushi, Arthashastra and Niti Shastra. These are the scriptures written by Mr. Like you said, Dr. Chanakya or Pandit Chanakya. We could give any designation to the person of the olden times as per our today's norms, because he gave us these scriptures which have immense knowledge about how law, legislation, and punishments should work.
So all you So you're saying that law and legislation have been established for since long. But what is today's conference about?
Well, today's conference is from Society for Prevention of Injuries and Corporal Punishment, SPIC. We will be talking about the topics of injuries to children and other forensic perspectives related to it. Let's begin with the workshop.
Yes. Sure.
So now we are going to begin with our today's first presentation by Dr. Pradeep Singh, Professor and Head Pandit Jawaharlal Nehru Government Medical College, Chamba, and he's going to present upon the topic overview of POCSO Act. A big hand for him, please.
Good morning to everyone, especially Dr. Guria sir, Dr. Pramod, and Dr. Malhotra, Dr. Akhilesh, Dr. Yadupul, and other faculty members who are present over here, and especially the students who have come in abundance. And this is also a learning experience for all of you, because this is a conference that you will get to know or come to know various things that you haven't learned in your MBBS course, and more importantly, the skill that is how to organize these types of conferences, CMEs, and how whatever these students are doing, the anchoring and small parts registration, whatever that is happening, I am inviting and saying hello to all of you and good morning. And now my topic of today's presentation is child sexual abuse. It is quite sensitive topic, which being as Indian, we don't want to discuss. And but these things are happening nowadays with our children. So what being as adult, what we can do? A trained adult can protect an average of 10 children from the sexual abuse. That is the ground reality, which we should have to take the responsibility. Many of us, being as parents and guardians, and being as teachers also, are very much disturbed, angry, and intensely anxious about security for school-going children, and particularly if the caregivers or the servant who is taking care of our kids, that he or she is going to commit this type of crime. As parents and citizens, unaware of the provisions in different acts pertaining to protection of our children against such offences. Various types of offences are there, but the POCSO Act is one of them. What is the perspective? What is the data that is available in India? That is one of the child sexual abuse, one of the biggest evil in our country. Every second, a child is sexually abused, and 5.3 million children, they are forced into commercial sex work in the age group of 5 to 18. And 5 lakh children, they are forced into commercial sex work per year. Children with disability, that may be physical or mental, they are 4 times more abused than the other. Now, what are these data? The NCRB, National Crime Record Bureau data, that it has recently described. India is the top country for child sexual abuse material. According to Women, Peace and Security Index 2023, India ranks 128 in 177 countries. 24 lakh cases of online child sexual abuse from 2017 to 2020 has been reported, and total of 19,765 cases were registered under POCSO Act in 2016. That was the data in the 2016 that is released by NCRB. Now, in 2022, 1,62,000 cases of child sexual abuse has been reported. So there is an increase of 96% from 2016 to 22. Kidnapping and abduction, that will contribute 46% crime against the children in the India. Most number of crimes against children were reported in the Uttar Pradesh UP. That is 38,444, and more these girls are involved. In Maharashtra, 7,572, and MP 5996, and HP that is 9, and UT Delhi that has reported 1512, and Punjab that has reported 2492. But these cases that is registered online, offline by the parents, teachers, or whosoever has got this knowledge. But this is just the tip of the iceberg, because I know if I will talk about the Himachal Pradesh from where I am coming, this is not the only 9 cases that have been reported that have come to our preview. I am posted in Chamba, Himachal Pradesh. More specifically, we have come across 15 to 20% of these child abuse cases, but these are not reported well. If we talk about the whole Himachal Pradesh, these cases may fall or may go up to hundreds of thousands cases. So that is also the case with other states also. And the parents and the guardians, or being the relatives, they are the biggest abusers. 76% they will contribute. Children with special education needs and disability, they are more at risk. And we will talk about the conviction rate till date. That is only 2.56% in all the rape cases. And in 7 to 10%, 7 to 10-year children, 360 360% increase in sexual imagination by watching all these YouTube and various available material with all these children. So we are also putting our children to all these types of abuses online that are available. Pending trials under POCSO Act, that is 2,43,237 till January 31, 2023. Fast, it is in the fast track special courts that are constituted by the Supreme Court under this guideline. 11 lakh children, they are posted for child marriage in 2023 to 2024. 28.9% children, they will experience some form of sexual abuse or crime. This is also not so much reported cases. If we talk about whosoever that we are sitting here, somewhere or some in the life, we have also experienced in the childhood some type of child sexual abuse, which we haven't reported or our parents or others haven't reported to the authorities. So these cases, not only 28.9%, that may be 99% of the audience, if we are sitting here, we will talk about with ourselves, and we know, this is not the case that is important. Social and economic factors for all these child who is giving the care to our children, and poverty and lack of education and stressful living conditions for the caregivers that will lead to the child sexual abuse. Now, what is the definition of the child sexual abuse? It is in which an adult and older adolescent uses a child for the sexual stimulation. That is definition of child sexual abuse. Now, how we can come to know that our kid or children is having somewhat of child sexual abuse symptoms or signs? That is the STD, sexual transmitted disease in the child, pregnancy at an early age, frequent UTI if he or she is experiencing, genital injuries and physical feature, blood in the underwear, sexual knowledge that is not age appropriate, the knowledge that he or she wants that is not required at his or her own age. That is aversion to go home. The child will say that I want to go to home early, and child discloses the abuse to the parents, and the children are wearing multi-layered clothes. And depression, that is also a behavioral sign. Now, what is now alarming? Only 1 in 10 victims of the child sexual abuse, they will disclose this type of abuse. Now, what is the background? After unfortunate incident, Delhi gang rape case, we all know that happened in 2012 and later in Kathua rape case and murder of 8-year-old girl. People want the stringent punishment for the rape accused. So, in order to address this problem, child sexual abuse, through more stringent legal provision, POCSO Act, Prevention of Children from the Sexual Offences Act, come into force on November 14, 2012. And also, the government of India has established one-stop centers across the country. So, all we know it that is available at the government institutions or private institutions. Now, effectively, we are set up all these types of one-stop crisis center also. So now what is this Prevention of Children from Sexual Offences Act, POCSO? It is a POCSO, not POSCO. And that is also a confusion in all of us. That is gender neutral legislation. It's not relevant or to the only to the girls, boys, if they are having this type of abuse, they can also report it. So Act define children as any person below the age of 18 years. 18 साल से जो बच्चा कम है, that he can report this case. Now what is this principle? That is effective assistance, privacy, safety, and compensation. This will list all forms of sexual assault, including touching and non-touching behavior and gestures. What are these salient features? That is quite child-friendly. Police protection will be available during all the investigation, and the child can also testify through the video conferencing. Pre-emergency medical treatment is also available. There are also the provisions for avoiding re-victimization of the children, and the burden of proof should have to be by the accused, not the victim. And the special courts has been established to decide for the compensation for the child. Now, what are the procedures incorporated on POCSO Act? Recording statement of child at the residence or at a place of his choice, and the police inspector, that is the sub-inspector, who is reporting all these cases or undergoing the investigation, he should be not below the rank of SI. Evidence has to be recorded within 30 days of the reporting the case. No child is detained in the police station in the night for any reason. No aggressive questioning or the character assassination of the child. POCSO Act, it has got various sub-clauses. First one is penetrative sexual assault, sexual harassment, using the child for pornographic purposes, trafficking of the children for sexual purposes, and above all these offences become aggravated when the child is mentally ill or committed by a person in a position of trust or the authority. Now, what is this penetrative sexual assault? The person will penetrate his penis or any object to any extent into vagina, mouth, urethra, anus of child, or makes a child to do with him or any other person. And he applies his mouth to penis, vagina, anus, and makes to do this type of abuse. The sexual assault, touching with the sexual intent, the vagina, penis, anus, or breast of a child, and makes the child to do so, or involves physical contact without the penetration. The sexual harassment, the person will utter any word or make sound with bad intention, or make child exhibit his body part, or shows any object to a child in the form of media for pornographic purposes, or repeatedly or constantly follows or contacts a child, and threaten to use any form of media, and the punishment for this is 3 years or with fine or with both. Use of child for pornographic purposes, representation of the child organ of a child, engaged in rear or stimulated sexual act with or without penetration, indecent representation of the child, covers mere viewing, possession, and storage of material showing a minor engaged in sexual activity. The person is having these types of material in his own mobile or laptop. If his intention is the child abuse, then that person should be uh, booked under POCSO Act. Aggravated assault, when the child is abused, is mentally ill, or by a person in a position of trust or authority, like the family member, police officer, teacher, being as doctors and caregiver, they also will come in the aggravated assault. When the crime is committed more than once, and when the child is below the age of 12-year age, gang assault, when the more than one person is involved, when offense causes a life-threatening injury, and the person or the child will go into coma, or he or she is physically disabled after the assault, then it also becomes the aggravated assault. When the offense committed or the child made to strip or made naked in public, and that is committed by a person previously convicted of offense either under this act or any other act, that is also becomes a aggravated assault. When the offense is committed in communal or sectarian violence, that we have seen in various types of disturbances that are happening in the wars. Now, what is the attempt and abetment? Intention to commit an offense even when that is unsuccessful. Person is not able to do the sexual assault or sexual crime, then it is also punishable. Attempt to commit offense made liable for the punishment up to half of the punishment prescribed for the commission of the crime. Abetment means forced to do the crime. The child is forced to do the crime, and that is treated with same gravity as commission of the crime. So full or whatever the punishment that is prescribed, that is given to that very person. So these are the various types of punishment that will range from 3 years up to 20 year or life imprisonment, or death may also be granted to that very person. Now, what are the responsible units for recording all these types of crimes? That is Special Juvenile Police Unit that will provide relief and rehabilitation of the child within 24 hours. As and when the child or the parents will report this case to 1098, 1098, that is the child helpline. So the police will come into action, and they will immediately come in contact with the child, and then the child welfare committee or local police report to the child welfare committee, that is within 24 hours of the commission of the crime. Then you also the central and state governments make these types of awareness through media to the general public and parents, and National Commission for Protection of Child Rights, NCPCR, and state commissions for protection of the children. So they will monitor the implementation of the act. Now, this is also important for all of us. That is the POCSO e-box. If we do not want to call the police by 10, 9, 8 page, 100 page, 112 page, there is also the POCSO e-box. You can also open on your mobile. There is also the online complaint management system for easy and direct reporting of the sexual offences against children, and timely action under the POCSO Act should have done. E-box that will be incorporated in the homepage of the NCPCR. You can also note down the website. So what this Himachal Pradesh government has done, they have put the POCSO box in the Himachal Pradesh schools. School पे छोटे-छोटे boxes लगे हुए हैं. If the child given in writing, जैसे वो हमारे एंटी रैगिंग वाले हैं, वैसे ही उन्होंने ये वाले बना रखे हैं. आप में कंप्लेंट डालनी है, भी ये हुआ मेरे साथ, this person is involved, and the headmaster or the teacher will report this case to the authority concerned. So the government of Himachal Pradesh directed all the government as well as the private schools to put the POCSO boxes to report the sexual abuse cases. These boxes will be opened every week under the supervision of the school principal. The season came after the national awardee teacher भाई थे वहां पे, ठीक है ना, रोडू से, हिमाचल प्रदेश से, जो उन्होंने रिपोर्ट किया. सो दैट्स व्हाई दिस POCSO boxes has been come into play. Emergency numbers should be painted on the walls of the schools, and CCTV will already have been installed in the 164 schools of the Himachal Pradesh, and the budget of rupees 500 to each school has been given. So now what are the duties of the police or the special juvenile police unit? They will make the availability of the medical services, availability of the victim compensation, arrest of the offender, dates of court proceeding should have to be communicated to the parents or the relatives, bail or the release of the offender, what is happening with the accused, what are the proceedings that is going on, that should be communicated to the concerned parents. What is the sentence imposed on an offender? Please inform the special court within 24 hours, and the police officer should record the statement of the child as spoken by the child. He, being the police officer, should not suggest or make any changes whatever the statement of the child or parents will be. As such, they should have to write it. They also register FIR, and they also provide the copy of the FIR to the complainant, and they will ensure sample collection for forensic examination. And if the police officer fails to register case, that's also a punishable case. Now, recording of the evidence, police officer not to be in the uniform. पुलिस की यूनिफॉर्म पहन के नहीं आएगा, वो सिंपल वाली जो है वहां पे आएगा रिकॉर्ड करने के लिए स्टेटमेंट तो बचे. The assistance of the interpreter, the translator or the expert as per need of the child. अगर बच्चा छोटा है, नहीं समझा पा रहा है, या उनके पेरेंट्स की जरूरत है, जहाँ पे उसकी लैंग्वेज समझ नहीं लग रही है, then the translator or the interpreter should have to be supplied by the police officer. And there are also the frequent breaks. बच्चे को बार बार एक टाइम नहीं, उसकी स्टेटमेंट एक बार ही ले लेनी. द फ्रीक्वेंट ब्रेक्स, उसको जो नहीं कंफर्टेबल लग रहा है, ठीक है, बोला मैंने खेलना है, लेट हिम प्ले. बोला वॉशरूम जाना है, लेट हिम टू गो देयर. मतलब हमने उसको बार बार जो है ब्रेक्स देनी है, इफ द चाइल्ड बी कंफर्टेबल विद अस, एंड द चाइल्ड कैन नॉट बी कॉल्ड रिपीटेडली. बार बार नहीं बुलाना है, दे दो जी आ गए. ट्राई टू कंप्लीट द स्टेटमेंट इन वन गो. And care and protection, if the police and the SPJU believes that a child needs care and protection, immediate make arrangement and also the child welfare committee. CWC ensure child care and protection of the children, and they can also order that child is taken care out of the custody of the family. Kadon, if he or she has been or likely to be abused by the parents. पेरेंट्स ही ऑफेंडर है, तो वहां से उसको रिमूव करना जो है, दैट इज आल्सो बी द चाइल्ड वेलफेयर कमिटी. रिकॉर्डिंग ऑफ द एविडेंस बाय द स्पेशल, दैट इज रिकॉर्डेड विद 30 days ऑफ द ऑफेंस. 30 दिन ਦੇ ਵਿੱਚ ਵਿੱਚ ਦਾ ਰਿਕਾर्ड जो है एविडेंस, दैट शुड बी डन बाय द स्पेशल. स्पेशल कोर्ट शुड हैव टू कंप्लीट द ट्रायल विद इन 1 year ऑफ द ऑफेंस. एक साल ਦੇ ਵਿੱਚ ਵਿੱਚ उसका ट्रायल जो है, दैट शुड बी कंप्लीटेड. Now, few cases are there, उन्होंने 3 महीने में ही सजा सुना दी है ना चाहिए, जो है बड़ा the offense. This is also a commendable job by these courts. That will also ensure the child not to expose in any way to the accused. The accused मुंह मुझे सामने नहीं लेके आना, जो चाहे बच्चा जो है या पेरेंट्स जो है. So there is also a emotionally the child will get disturbed during the evidence, while at the same time ensuring that the accused hears the statement. Whatever that has been recorded, you can also record the statement of the child. Then that very accused who has सुन ले नहीं है, तो then he can prepare his reply, and that will also be communicated with his advocate. Recording of the statement by the magistrate. Any statement recorded in the opinion of the magistrate that is best fitted to the case, not that will apply as spoken by the children. ऐसा नहीं है बच्चा कई बार कम्युनिकेट नहीं कर पाता है, जो स्टेटमेंट है दैट इज मोस्ट बेनिफिशियल to the child, that should have to be reported. पुलिस वाले का क्या था, वट एवर द चाइल्ड, उसके पेरेंट जो हैं जो रिपोर्ट कर रहे हैं लिखवा रहे हैं सेम लिखना है। बस इस मजिस्ट्रेट जो है he or she can make the changes that is best suited for the child. Role of the state agencies, that is different agencies of the state, police, judiciary and child protection machinery, that will secure the justice. Media is also barred from disclosing the identity of the child without permission of the special court. There is also a punishable offense if the media is publishing the name of that very child, the photograph of that very child. Punishment for breaching by the media, that will vary from 1 month to from 6 months to 1 year punishment that is to be given. And also they will formulate the scheme for the compensation. There is also guidelines for the doctors and the NGOs. Now, reporting by person close to the child. No person that is punished either by civil or criminal court who is reporting this case. So, Act will provide mandatory reporting of the sexual offences. The legal duty upon a person to report the offence that child is sexually abused. If he fails to do, and that is also punished with 6 months imprisonment or fine. There is also a she box, SHE. HE. There is also a box, there is an online complaint. You can also open the mobile. There is also an online complaint you can lodge with the central government that is available for the public sector and autonomous bodies. If there is some workplace women that are harassed. If there is false reporting, what should have to be done? That is Section 22 of the POCSO Act that prescribe punishment for a person if that will give the false information with intention to defame any person or including the child. उसको बदनाम करना चाह रहा है बच्चे को, parents को, that whatever that will be. Such punishment should be kept light or low. That is only 6 months to encourage reporting. जिसको report करेगा जो person जो है. If that is false complaint made against children, then the punishment is higher. That is 1 year. Why the child don't disclose, do not tell that is happening with him. Now, do not know the abuse is wrong. उसको लग रहा है अभी ठीक ही हो रहा है. No problem in, and may also feel good, and he or she is also told it is okay, and feel that is also felt that child feel that it is his fault, her fault. That's why he or she is sexually abused, and do not know who or how to report, who to tell, क्यों दसना, क्यों बताना. Love and care for the offender. Parents हैं, guardians हैं, प्यार है उसके साथ ही. So that's why that very child do not report. Fear that no one will believe them. Afraid of hurting or getting people in the trouble. Now, what are the parents' expression after the child is sexually abused? They will experience, they will say that deny करेंगे, गुस्सा होंगे, betrayal, confusion, disbelief. Parents often tend to blame themselves, जिन्होंने बच्चों का ध्यान नहीं रखा. Feel that the parents and did not protect their child. Some parents wonder why the child do not disclose this offense to them. सानू क्यों नहीं दसिया, टीचर ਨੂੰ क्यों दसिया, ਜਾਂ ਕਿਸੇ ਹੋਰ ਨੂੰ दसिया. And some parents become angry at themselves or at spouse, husband wife के साथ गुस्सा होने लग जाते हैं कि तुम सपोर्ट नहीं कर रहे हो तुम. Insomnia, नींद नहीं आती पेरेंट्स को जो है, और physical complaint will also be there. Now, what is the role of the doctors? Issue of consent लेना है हमने, valid जो है. Lady doctor should examine, even without FIR, we should have to do the medical examination. Counseling should be done before the medical examination. Medical examination should be performed in the presence of parent or in whom the child has got the trust. Treatment should be provided immediately, free of cost. That may be at the government level, at the private level. The treatment should be free of cost. Medical examination, that should be least distressful. No hospital refused to admit the victim of the child sexual abuse for examination and the treatment and legal procedure can be done later after initiating the medical care. Nowadays, what is happening in our institute, police is requesting or making the complaint or saying request to us, बिडर साहब ਇਹਦੀ ਨਾ ਕੱਲਾ फिजिकल एग्जामिनेशन करना, जो जेनिटल एग्जामिनेशन या लोकल एग्जामिनेशन करना ही नहीं है. So these cases are coming to us. So this you should have to decide whether that is required or not. Register medical legal case in all the cases of child sexual abuse and collect the evidence, appropriate evidence, and should treat the physical and genital injuries if that are there. And age assessment should have to be done of the victim. Offer the prophylaxis treatment of the STD and other contraceptive measures you should have to take. Monthly follow-up at least 6 months to look for development of the psychiatric disorders. And family counseling should have to be done. And assist the court in interviewing the child and testifying in the court. Now, what are the factors for the compensation? That will be on the basis of the type and gravity of the abuse and the harm suffered, expenditure, loss of education, opportunity, employment, relationship with the child, single instance abuse, whether child has contracted HIV/AIDS or disability that he has suffered, financial condition of the victim or the family. Only the 70% of the fund that has been under the head of Nirbhaya fund that has been utilized so far, not for the compensation. Most of this has been utilized for the advertisement. So this is also a drawback. Compensation not accused, essential accused need to be convicted. वेट नहीं करना भी उसको सजा हो ना हो. The compensation should have to be provided to the child. That should not be less than the 10.5 lakh for physical, mental, or immediate compensation. That is under section 33(8) by special court. And the state government must pay compensation to the victim within 30 days from the date of the special court. There is also a free provision for the legal aid. Now, how being as parent, we can prevent the child sexual abuse. We should have to teach the child good touch, bad touch, open communication with the children. बार बार पूछो जो घर तो आਉਂਦੇ ਕਿਵੇਂ ਆ ਕੀ ਹਾਲ ਕੀ ਕੀਤਾ ਸਕੂਲ ਚ any discomfort what is एक दो मिनट ही लगाने ज्यादा टाइम लगाने की जरूरत नहीं होती बच्चों को. You should have to communicate with the child every day. Body parts, they should have to describe them. Unsafe secrets जो उनको लग रहे हैं बच्चा सीक्रेट जो है नहीं रखने हैं भी that would be unsafe for the child. So later on they become the safe one for the child. Now self-esteem and respect the children's boundaries. So these are the few books that we can parents को भी पढ़ लेनी चाहिए और बच्चों को भी दे देनी चाहिए ये वाली जो है. इसके कुछ ड्रॉबैक्स भी हैं. पॉक्सो एक्ट वाला जो है हमारा, if the child refuses to undergo medical examination, act remains silent. No clear guidelines are there. Child marriage still going on. हिमाचल में भी है, यूपी में भी है, राजस्थान में भी still going on. Reporting provision, mandatory reporting, failure, what fine, imprisonment, parent, they will be in the legal trouble. Separation to the hospital and shelter home that will lead to the social difficulties and problem in the implementation of the act without training of the police, judiciary, or especially the healthcare professionals. Now, summary, POCSO undoubtedly had made the significant contribution tackling of the problem of the child sexual abuse in India. It identified and criminalized a range of unacceptable sexual behavior posing threat to the children. Number of reported cases, they are increasing day by day, indicating that the law has made the substantial contribution in the educating people, sensitizing criminal justice system, and making reporting not just acceptable but also mandatory. Medical professionals should report all the cases of the sexual abuse to the legal authorities. Multi-dimensional, multi-agency team, multi-tier approach, and psychosocial support should be made available under one roof for the victims of the child sexual abuse. Children make the world bright, but still they struggle to see the light scenario. This is Paul John Shoshan, छोटा सा poster है ये वाला. So my sincere request to all of you is don't be a mute spectator or a listener to the child sexual abuse. Report it and come forward and lodge a complaint to 10 at 1098 or 100 or FIR. You can also fironline.org. Can we all end the child sexual abuse? Definitely. Take home message, remember 1098. Every citizen bound to inform the police about the child sexual abuse. POCSO e-box is available and FIR online we can register. Thanks to all of you. Any query if you have what you can ask. Any query from the students? It means सारा समझ लग गया है ना. Thank you so much.
Thank you, sir, for your wonderful insights on POCSO Act, which enhance your knowledge. The responsibility comes on our shoulders. Don't be a mute spectator. The steps need to be taken by us.
Napreet, so at the start of the conference, I saw you fumble. Were you diffident about your forensic knowledge? Because I've never seen a person of your stature fumble at an official conference like SPIC.
Arushi, you give the answer yourself. You know it's all about nature. A person standing 6 feet 5 inches tall and whatever your height is. When we were about to share our mics, we were also fumble, you know.
Question directed to my forensic experts. Is it possible to escape BS section 101 and 103? That is, the sections that define murder and punishment for murder?
Honorable Secretary, sir, is it possible that if a person standing 5 feet 1 inches tall tries to injure a person standing 6 feet 5 inches tall and injure herself badly on the face would be counted as previous hurt under section 113?
Moving on. This is an official conference. Now please say, so maintain your demeanor.
Indeed, it is Arushi who started it first.
So for our next discussion, I'd like to invite Dr. R.K. Goria, who is the founder for Society of Prevention of Injuries and Corporal Punishment.
He'll be giving his valuable insights on the topic scenario of corporal punishment in India and around the globe. A big hand for him, please.
ये पॉइंटर है, पॉइंटर है क्या ना लगा लो, आराम ना लगा लो, आराम ना लगाओ 1 मिनट. There, light stream. Stream.
So I come from Tata University of Health Sciences. We start about children.
Dr. James, are you ready?
Yes, sir.
Just a minute. I'm making you the host, co-host, so you can share your screen.
Sure, sir. Sure.
Mic ना चाहिए होगा इतना क्या तो आवाज थी.
Is it audible, sir, now?
एक मिनट ऑडिबल थोड़ी आवाज. Just a minute. तुझा mic खोल mic. Till the time we are setting the sound, so I will just introduce our next speaker. Our next speaker is Dr. Ranjit Aminul James. He is from CMC Vellore. He is associate professor in the Department of Forensic Medicine. He has done his MBBS from Vinayaka Mission Medical College for Puducherry and MD Forensic Medicine from Kasturba Medical College, Manipal. That is my parent institute. And he also cleared his DNB Forensic Medicine. He has done his postgraduate diploma in consumer law and practice. And he's also hold an MBA degree from BITS Planning. And he has been best outgoing postgraduate student of forensic medicine of year 2017. And he has also got the travel grant award, Shri M.L. Madhukar Memorial Travel Grant Award for his KMLS Faculty Achiever of the year 22. So we welcome Dr. James, and his topic he will be speaking on euthanasia type. No? So Dr. James, he has been logged out, I think. Let him join him again. Just
Yes, sir. Sorry, it got disconnected, sir. Can I share the screen?
right, just a minute. Yes, you can share. You can share the screen now.
Yes, sir.
So, his topic is abolition of right to die in India. Do we have a right to die or not? So he will speak on that. So Dr. James, you can share your screen. Yes,
Yes, sir.
Yes, it's visible.
Yes. Yes. Good afternoon, everyone. So I would like to thank the organizing team of SPIC conference, especially Professor Pramod K. Goyal for this opportunity. So thank you, sir, for the kind introduction. So before, without wasting any time, I would like to go straight into the topic. So the topic for today's discussion is the evolution of right to die in India. So is it audible, sir? Can I continue?
Yes, you can continue.
So today's presentation will be structured in this particular fashion. First, we'll talk about the past, what has happened, tracing the history, and we'll talk about few case laws, which is crucial in understanding this right to die concept, and talk about few reports from the Law Commission in India and their perspectives, and the landmark verdict, Common Cause versus Union of India in 2018, and the modifications of the guidelines towards the end-of-life care issued by the Supreme Court in 2023. Now, when we talk about right to die, the first thing happened, to the best of my knowledge, is the Law Commission of India's report in 1971. There they have recommended to the government to delete Section 309 of the Indian Penal Code, which grants punishment or provides punishment for attempting to commit suicide.
And this recommendation was accepted by the government of India, and the Indian Penal Code Amendment Bill was introduced in the parliament. And in 1978, it was passed by the Rajya Sabha, and then but unfortunately, due to the dissolution of the House of people, the Lok Sabha in 1979, the bill without passing it got lapsed. Then in 1985, in State versus Sanjay Kumar Bhatia, the Delhi High Court, dealing with the appeal by the prosecution against a person who attempted to commit suicide. But the Delhi High Court felt that Section 309 continuation of that section is an anachronism and unworthy of human society like ours. And then the High Court highlighted the need for psychiatric care for such individuals who are attempting to commit suicide rather than confinement in prison cells alongside criminals. In 1985, the same year later, the High Court of Delhi has asked the trial courts to collect the data of cases pending against them with regards to Section 309 of IPC. So they have collected around 120 cases pending since 1972. And then the court has observed that the mindless mechanical process, both by the prosecution and unfortunately the trial courts, only serves to prolong the suffering of the victims, particularly those from poorer sections of the society. So in the interest of justice, the Honorable Judge has quashed the pending prosecutions in all these 120 cases and directed the immediate acquittal of all the alleged accused in those cases. Later, 1 year later, in 1986, a case was brought to the notice of Bombay High Court, where the Bombay High Court has noted that Article 21 of the Constitution recognized the right to life as a positive right, and it is not and cannot be seriously disputed that fundamental rights have their positive as well as negative aspects. So to put it positively, it would include right to die or to terminate one's life. And thus it declared Section 309 as unconstitutional and asserting it is a violative of Article 21 of the Constitution of India and struck down the provision. And again, 1 year later in Andhra High Court, the similar petition was brought about the validity of Section 309. And then the court has observed while Section 309 of IPC sets an upper limit for punishment, it does not mandate any punishment of attempt to commit suicide because the Probation of Offenders Act gives the discretion for the court to bind individual to psychiatric care or release them with admonition. So challenging the legality of Section 309 of IPC raises doubts about the survival of Section 306 IPC, which is about abetment of suicide. So potentially allowing those who assist suicide and suicide to escape punishment if we were to deem 309 IPC is unconstitutional. So the court has observed that it is prudent to err on the side of caution, especially in a country like India. And it held that it is not violative of Articles 19 and 21 of the Constitution, and thus it is valid. Later in 1994, PM Ratnam versus Union of India, the Supreme Court, Honorable Supreme Court, drawing a parallel with fundamental rights, ruled that just as the right to freedom of speech includes right not to speak, the right to life under Article 21 encompasses the right not to live. This right was said to arise from the notion that an individual has autonomy over himself and his existence. Consequently, Section 309 was deemed unconstitutional and void. This decision is aligned with the global trend towards humanization and globalization. However, in 1996, Giancor was a state of Punjab. The Honorable Supreme Court of India has said the notice that the defense argued. I will talk about the nitty-gritties of this case in the coming slides, but I will tell you the gist of it. In this case, the judgment of PM Ratnam case was reversed, and then the court upheld the validity of Section 309 IPC, affirming that this provision is not invalid under the Constitution. Whereas in the Law Commission of India again provided a report in 1997, which is after the Giancor versus State of Punjab. So in that, the court has, the commission has opined that following the Giancor judgment, the section 309 should be retained in the Indian Penal Code. The same law commission which recommended to be, the 309 to be repealed in 1971 after the Giancor judgment, they have said that it need to be retained. Then comes an interesting case in Kerala High Court, where a 80-year-old retired teacher expressed his desire to end his life voluntarily after leading a successful and fulfilling life. So he argued that this act shouldn't be considered suicide as he believed his life's purpose has been fulfilled. So he suggested that there should be voluntary death clinics which should facilitate people who would like to commit, voluntarily die. But the court emphasized that whether it is suicide is an impulsive or a premeditated one, it is immaterial to the legal classification, and then they quashed the petition. And next comes the initiation of SAGA, the Common Cause, which is a registered society, non-NGO, and they highlighted the pressing need to address the distressing pain and challenges faced by the elderly in particular, and the concern associated serious illness requiring hospital treatment. So people are getting, prolonged treatment or which might be unnecessary at that stage, which is just meant to prolong their life. And they said that they wrote to the ministry, they wrote to the Department of Law and Justice and various state governments to take actions against these and to come together to find a solution. But unfortunately, no such reply they got from these ministry and other departments. So they filed a writ petition in the Supreme Court of India in 2005. They are asking that, the Supreme Court to declare right to die with dignity as a fundamental right under Article 21 of the Constitution, and also to adopt procedures for authorizing living will and the role of power of attorney in healthcare. So one thing I want to highlight here is that the right to die with dignity came first was discussed in this 1986 judgment that Bombay High Court has said right to die may not be directly coming under the ambit of right to life, whereas right to die with dignity can be considered as a right under right to life under the Constitution. Then comes our 2006 Law Commission of India report, which was taken up by the initiative from the Indian Society of Critical Care. So they have studied in detail about this matter of, terminally ill patients and various laws in other countries. And then they have drafted a bill, which is called Medical Treatment to Terminally Ill Patients for Protection of Patients as well as the Medical Practitioners Bill, 2006. So then comes 2008 report, which talks about the constitutional validity of Section 309. So this Law Commission has revisited this 309, and they have said that the Giancor judgment in 1996 has not delved into the practicality of or continued relevance in the legal framework. They have just said that based on the facts of the case. So they have discussed with WHO, International Association of Suicide Prevention, along with representation from the Indian Psychiatric Society and other stakeholders. And they have said that while aiding or abetting suicide warrants punishment, Section 309's inclusion in the Indian Penal Code is unnecessary, as criminal law should intervene only when it proves to be an effective remedy against the intended harm. So that was the observation given by this Law Commission. Then comes the landmark judgment, which we all know, Aruna Shambhag versus Union of India in 2011. And I don't have to go into the details of what happened in the case. So the final verdict is that passive euthanasia was legalized in India for the first time in this case. So we will talk about this case after a while. And then shortly after this judgment was pronounced by the Honorable Supreme Court, another Law Commission report was published. So before this, the Supreme Court has asked the government or recommended the Parliament to consider decriminalizing attempt to suicide, saying that the provision has become anachronistic. So the government has agreed to the proposal to bring out an amendment to delete Section 309 IPC as it comes into the concurrent list. Therefore, the central government took the approval of 25 states out of the 29 states at that point of time. However, it did not materialize. So this Law Commission report of 2012, which is similar to the 2006 Law Commission report, so the same bill which was amended based on the developments of Aruna Shamba case. And then comes our 2017 case Puttaswamy versus Union of India, in which the Justice Chalameswar in this case has observed that an individual's right to refuse life-prolonging medical treatment or terminate his life is another freedom which falls within the zone of privacy. So they have acknowledged that it falls within the right to privacy. And the same year, Mental Health Act 2017 was enacted, and Section 115, subsection 1 of Mental Health Care Act 2017 limits the scope of Section 309, and it gives a presumption of severe stress in case of attempt to commit suicide. So that's limiting the scope of Section 309 IPC. So then comes our landmark verdict in 2018, which we will talk about in the coming slides. So before this, after this Mental Health Care Act enactment, many cases, high courts have quashed the criminal proceedings against alleged accused in case of attempt to commit suicide, citing this Mental Health Care Act 2017. And then comes 2023 modified guidelines by this Honorable Supreme Court of India. And then now we have the new Bharatiya Sanhita, which repealed the IPC. And this BNS 2023, attempt to commit suicide is no longer a crime under BNS. However, abetment of suicide is still a crime under Section 108 of the BNS. So this is the overall development in our country with regards to right to die, which started with right to die and attempt to suicide. However, over a period of time, it has evolved into right to die with dignity, which is being considered or pronounced as a fundamental right by the Honorable Supreme Court in Common Cause versus Union of India 2018. The important cases which we need to deliberate upon is these two before the Common Cause judgment. So the Jian Kaur versus State of Punjab in 1996, the Jian Kaur as well as her husband was charged under Section 306 of IPC for the death of the daughter-in-law. And then the trial court has convicted them, and the High Court also has convicted them. And they challenged this petition in the Supreme Court, saying that, citing that 1994 judgment, PM Ratnam versus Union of India judgment, saying that since 309 IPC is considered or held constitutionally invalid, how come 306 be considered as a crime? That was one of the defense put forth by them in the court of law. For that, the Supreme Court has said that the right to life also includes the right to a dignified life till a person reaches the point of death. And this right to die with dignity at the end of life in individual's life should not be confused with right to die in an unnatural manner of death. And then right to life is a natural right embodied in Article 21 of the Constitution, but suicide is an unnatural termination or extinction of life, and therefore incompatible and inconsistent with the concept of right to life. And they have also said that it should not be conflated that, suicide or abetment of suicide is considered as right to die with dignity. And then they overruled this 1994 judgment, and they also upheld the judgment of the trial court as well as the High Court and convicted these two. And in Aruna Shamba case, 1973, we all know what happened. And then the writ petition was filed in the Supreme Court by a journalist, and to allow her to die peacefully and to withdraw the life support. However, after thorough deliberation, the Honorable Supreme Court of India has declared that the right to die, passive euthanasia is legally valid. However, they dismissed the petition for this particular case, which is a paradox. And they have issued some guidelines stating that till the Parliament comes with the legislation, the High Court will be the authority to decide petition for, withdrawal of life supports. In the Law Commission of India 2006, as I said, the bill name was Medical Treatment of Terminally Ill Patients, Protection of Patients and Medical Practitioners Bill, which was drafted based on the discussions and deliberations with the Indian Society of Critical Care in their 196th report. So it was very well clarified in the report that the patient must be suffering from a terminal illness by virtue of which extreme pain and suffering is caused, and it must be ascertained if such a suffering will inevitably cause the death of the patient. Those were the only conditions which were highlighted in this. However, after this Aruna Shambhag judgment, I mean, the main important thing is that under Section 309, the patient also will be protected, and the protection of doctors also is there against Section 306 and 304 IPC and culpable homicide also, since it is trying to protect them who are acting in the best interest of the patient according to their wishes. And this 2012, the same bill was amended based on the development from the Aruna Shambhag case, where they had made the High Court, recourse to High Court a mandatory one, as suggested by the Honorable Supreme Court in the Aruna Shambhag case in 2011. Before, in the 2006 bill, it was not the case. So otherwise, more or less, the bill is same. In the Common Cause versus Union of India, as we talked about, it's 2002, they approached the ministry as well as various departments and governments. No reply were sought by them, given to them. So they filed a writ petition in the Supreme Court for two main reasons. One is to declare right to die with dignity as a fundamental right under the Article 21 of the Constitution, and to validate, make advance directive a valid thing in India, as well as power of attorney in healthcare. So the Supreme Court has accepted this. It's a historical judgment that Supreme Court of India accepted this plea, and then they have issued guidelines, and then we'll talk about these guidelines in a while. In 2023, these guidelines were modified based on the petition from the Indian Society of Critical Care Medicine. They have said that it is the procedures are a little cumbersome. It may not be possible for every common man to, approach a judicial magistrate first class for all these things. And then to streamline this process, they have suggested some changes, and after discussion with the Union of India, and then some of the changes were done. So those were the modified guidelines, which is in effect now. So let's just compare what are the, just quickly highlighting the key changes which is there from the 2018 as well as 2023 guidelines issued by the Supreme Court of India. So initially they were saying that it should specify the name of the guardian or the close relative in the as a power of attorney in their advance directive. However, in the 2023, they have given the scope for multiple people to be named. And signing of the document, initially they were saying that it should be countersigned by the judicial magistrate first class, so designated by the district judge concerned. But lacking that, the ordinary citizens will find it difficult to gain access to a judicial magistrate first class. It also adds to the existing workload of the magistrates in the courts. So they have removed this segment. Instead, they have added that attested before a notary or a gazetted officer. And then documenting the process, again, witness and the judicial magistrate first class should be there, but in the revised guidelines, notary or a gazetted officer should be there to record the satisfaction of their advance directive. And then in the 2018 guideline, the role to inform family members about this advance directives was placed upon the judicial magistrate first class. However, in the 2023 version, the burden was placed on the executor themselves, so that it is their duty to inform their family members and their family physicians, if at all any. And the roles of judicial magistrate first class were completely removed from this 2023 guidelines, which was there earlier in the 2018. So these are the provisions which were removed in the 2023 amendment guidelines. Preserving copy of a document, they initially said that it should be maintained with the courts, but then they have initially they said that the municipal corporation or municipality panchayat should have the copy of the document, so that whenever is needed, it can be verified. The argument was that they are not the competent authority to hold the documents in their custody, and then it will be more cumbersome to proceed with it. But the Supreme Court has not modified that set, but they have added that the executor may also choose to insert their advance directive as a part of the digital health records, if any, which is not the norm nowadays in India, but in future it may be a regular practice. Treating doctor, whenever they come across such news about the advance directive when they are treating a terminally ill patient, it is their duty to verify the advance directive, and then they should get it from the custodian that and then verify the document, and they should make sure that the patient does not have the decision-making capacity. And then with the reference to the existing digital health records, if any, are from the custodian of the document, they can proceed with it. So acting on the advance directive, they should make sure the nature of illness is irreversible and then availability of medical care is limited to that condition, and the consequences of alternative forms of treatment and remaining untreated, everything should be explained to the person who is listed in the advance directive as the power of attorney of healthcare or the executor. And then he must also ensure that he believes on the reasonable ground that the person is in question understands and the information provided by the treating team and has cogitated over the options and has confirmed to firm view that the option of withdrawal or refusal of medical treatment is the best choice in the given scenario. So these are the old guidelines which was laid down by the Supreme Court in 2018. So I will just briefly highlight the things. So if you see here, once the medical board is formed to decide, HOD of the concerned department under which the patient was admitted is supposed to be one of the member in the panel, along with 3 experts with 20 years of experience, more than or equal to 20 years of experience in the field of neurology, cardiology, general medicine, nephrology, psychiatry, or oncology, with experience in critical care. And then once the preliminary opinion of the board is given, then they should inform the district collector, who will then initiate the formation of the medical board, and which will have a chief district medical officer along with 3 other experts who are not part of the first board, and who also should be from the same specialties with more than or equal to 20 years of experience from either medicine, cardiology, neurology, psychiatry, or oncology, with experience in critical care. However, the most crucial point is that after if they also confirm with that, then they have to involve the judicial magistrate first class, who will then come to the hospital and then visit the patient and then check all the documents. Then he only authorizes the implementation of the wishes of the patient, which is listed in the advance directive. However, if in any case, if there is a discrepancy with the preliminary opinion, they can approach the medical board, and then the secondary board, if they reject the application or the request for withdrawal, then the patient party can appeal to the High Court, which will then form a medical board with 3 experts with more than or equal to 20 years, and then decide based on that, and then pass order with regards to withdrawal of life support. So this was the 2018 guideline. However, in the 2023, if you see, the major change is that the primary board should have the treating doctor in the team along with 2 experts instead of 3, and then who should be specialized in the medicine, cardiology, neurology, and psychiatry or oncology with experience in critical care. Then their experience should be minimum of 5 years instead of 20 years, because one of the arguments is that it is very difficult to find people with more than or equal to 20 years of experience when on everyday practice, and it may not be accessible for everybody. And then once they should visit the patient within 48 hours, and then they should form an opinion. And then if they say yes, then they should go on to secondary medical board, which will, in that board, chief medical officer of the district will nominate an RMP along with 2 other experts who are not part of the primary board, with again the same qualifications will be there. So by the time the secondary medical board also feels that the advance directive wishes can be implemented, in this step is very crucial. Previously, the judicial magistrate first class should authorize. However, here the hospital needs to inform the judicial magistrate first class, need not wait for them to come and check and all those things, and then they can directly go ahead and implement the advance directive. Whereas if at all, at any point, if there is a discrepancy, they can appeal to the secondary medical board if the primary medical board does not thinks that the patient should be withdrawn from the life support. Whereas in the secondary medical board, if they disagree, then either patient party or the judgment says even the hospital representative from the treating team also can approach the High Court if there is a discrepancy in coming to a consensus about withdrawal of life support. And again, the same procedure with regards to High Court, how medical board will be formed, and then finally passing of the order. These 2 things what I have talked about is only when the advance directive is available. However, the Supreme Court has given guidelines when when the advance directive is not available also. It is similar, but only thing is, since there is no advance directive at that point of time, the treating and the medical board should visit the patient and discuss with the family physician and the family members. The minutes of the meeting should be documented meticulously as to what all has been explained and what is the, whether what medical fertility is there and what kind of options are available. And finally, they should, with the consensus, they should come to a decision, and then they can proceed with it. So again, it is almost the same, similar to what we saw for the advance directive from that point of time. So I'm not going to explain all these things. This is the 2023 guidelines, little modified, similar to what we saw with the advance directive. And here, again, minutes of the meeting should be documented if family physician and the next of kin or friend or guardian, if the family members are not available, and minutes of the meeting should be documented meticulously to explain why such a decision has been taken. And then finally, implementation of that particular consensus, what has been decided in the meeting with the family members or the guardian or the friend or next of kin. So not only in legislation or in the judicial pronouncements or the judgments we have evolved. If you see from 2005, this was the first position statement from the Indian Society of Critical Care. They have given consensus statement from their society, our limiting life prolonging interventions, foregoing life sustaining treatments. Then after Arna Shamba case, they have modified their consensus statements. Then Palliative Care Society also came with the consensus statements. ICMR has come with a definition for uniformity in end-of-life care. Then KMC Manipal has come up with a document of Blue Maple, which is a comprehensive document to guide this end-of-life care. And they have revised it in 2021. First version was in 2019. Then ICMR came with the consensus guidelines for DNR. This was after this common cause judgment. And then finally, in March 2024, after this 2023 modified guidelines by the Supreme Court of India in Common Cause versus Union of India, the Indian Society of Critical Care and the Palliative Care Expert Association came together to form a position statement for end-of-life and palliative care in the ICUs. So this is the joint position statement where they have given a workflow based on the guidelines given by the Honorable Supreme Court in 2023, which may be useful for the clinicians who are working in the ICU setup. And this is a consensus statement which holds valid legally. So every step by step explain how to proceed and approach and discuss with the family members. And they have added one step that if there is no approval from the secondary medical board, the application can be submitted again to them, resubmit with justifications, or it can be directed to the clinical ethics committee to resolve the conflicts. So then they can proceed with foregoing life-sustaining treatments. So this is the workflow. And not only this, I think you might have heard about this 2023 guidelines from the Ministry of Health about ICU admissions. So those are all initiatives from this Indian Society of Critical Care in line with the to reduce the burden of people who are suffering from prolonged life treatment. And just wanted to say that we have come a long way in this process of end-of-life care, be it right to die, and from there to right to die with dignity being recognized as a fundamental right. So I feel still there is a long way to go in simplifying this process in line with the global standards in terms of procedural things. In principle, we are in line with the global standards, but in procedural things, there are some difficulties in the ground level. I think the ministry also has asked for feedback in giving the guidelines for withdrawal of life support. Soon they will release the final version. So once that is there, I hope the things will be much more easier in the ground level. And these are my references. And if there are any questions, I would be happy to answer. Thank you.
Thank you, Dr. James.
Thank you, sir.
Anyone wants to ask any question? Student, this is an important actually topic for your exam point of view also. The judgment that he has explained you in detail. Thank you very much. Thank you.
Thank you,
Dr.
sir.
Ranjit.
Thank you, sir.
Thank you for your part. Thank you. So for next session is the Dr. Pragnesh. After that, we will have a lunch break. For this next session, I will request Dr. Akhilesh Pathak from AIMS Bathinda to introduce Dr. Pragnesh.
Thank you, Dr. Pramod, and a very warm welcome, Dr. Pragnesh. I hope you could have joined us physically, but we can see you at least online. So, welcome, Dr. Pragnesh. I would like to introduce that Dr. Pragnesh is currently additional professor and head of the Department of Forensic Medicine and Toxicology in AIMS, BB Nagar, Hyderabad. So Dr. Pragnesh is working since a long time, especially in the area of the medical education. He has done so many publications in various national and international conferences, as well as he has attended various national and international conferences as a speaker, as well as on the various positions. So, very warm welcome, Dr. Pragnesh, and now it's over to you.
You can share your slides, Dr. Pragnesh. You are a co-host now. Pragnesh, can you hear us?
Hello. Yeah, I can hear you. There is some technical glitch. I think I was disconnected for a moment.
Okay.
So can I start? Hello, am I audible?
Yes, you're audible.
Okay. So let me share my screen. Hello.
Anil, yes, you're audible, but your screen is not shared yet. You're a co-host. I think you should
Hello,
be
is
able
it
to.
visible in full screen?
No, it's not visible. Your screen is not yet shared.
Oh,
Not yet. I think you log in again.
okay, so let me try. Now is it visible?
Yes, it's getting shared. Yes, yes, now it's visible. You can continue.
Okay, okay, okay. Yeah. So first of all, thank you very much, Dr. Akhilesh Pathak sir, for this nice introduction. And I am thankful to entire team of SPIC 2024, especially Dr. Pramod Goyal sir and Dr. Goria sir for giving this opportunity to appear online. Actually, I wanted to be physical, but due to some reasons, not able to come. So I will present today my topic on autopsy procedure on victims of infection death. What are the ethical and legal issues? As we know, recently we have came across the epidemic of this COVID, and then after the infectious death autopsy and everything came into picture. Before that, we are not that much focused on this part. So if we see what is infectious autopsy or high risk autopsy. So if we see whenever we are conducting any postmortem examination on a dead body who has or who is likely to have some serious infectious disease. He may be died due to that or not died due to that, that is secondary. But if he is suffering from any serious viruses or serious infectious disease, and there is possibility that it can be transmitted at autopsy to the person who is doing autopsy or whoever present in the autopsy room, or it may be transmitted in the atmosphere, then such type of autopsy we can consider as infectious autopsy or high risk autopsy. Now these pathogens, there are so many pathogens. We know that bacteria, virus, parasite, fungi, so many things are available in the atmosphere as well as in our human disease also. So they are classified many times in the high risk, medium risk, and low risk. And many are added, many are sometimes shifted here and there. So microbiologist are usually classifying that, and sometimes as a forensic pathologist or forensic person, we are not focusing on that part because we are not day to day encountering such type of epidemic or such type of infectious disease. But we have to be very careful because many times we are dealing with broad dead cases in which we don't know the past history. Either the person is actually suffering from any infection or not. So we have to take optimum precautions. So in this, we will first discuss which are the ethical and legal issues, which are some newspaper clipping I will show you which occur at the time of COVID. Some BNS sections, Bharatiya न्याय Sanhita sections related to this spreading of infection and what are the biosafety levels. So if we see certain ethical and legal issues, then usually when we are dealing with the dead body or doing autopsy, we don't have proper medical history of the disease. Either he is admitted for few days or brought dead. Because in few days of admission or few hours of admission also all type of investigation not occur. Or when time he is admitted for 3-4 days, all type of infection or all type of pathogens, no one is screening. So we cannot say this disease is not suffering from this XYZ infection. So we have to be very careful. Second issue we are encountering is there is no biosafety level 3 type of infrastructure or any other adequate biosafety level 3 infrastructure present in the India. As we know, in the COVID time also, few institute, I can say the name AIMS Bhopal has conducted autopsy and research on the COVID death, as well as in Gujarat also, government medical college Rajkot has conducted certain autopsy, but their infrastructure is not meeting the biosafety level 3, which should be there. And then after also COVID, I don't think so many more autopsy rooms having such type of facility. Mostly, if we see our autopsy work is distributed in primary healthcare center as well as the CSC as well as in the tertiary healthcare center in the medical college. In medical college, we'll find a neat and clean autopsy room and everything, which is mostly usually we are maintaining biosafety level 1. But if we see regarding primary health center or CSC, it is difficult situation many of the time. So here the situation is that we have to improve our infrastructure if we want to deal with such type of pathogen. Second thing is lack of trained manpower. As we know, even ourselves are not trained to work in certain biosafety level laboratories. And our assistant who are helping us, mortuary technicians or other things, they are also not qualified. We are not running any qualified course that they trained how to deal with the dead body and they will follow all these precautions. Second thing, lack of proper guidelines. In COVID also we have seen there is no such guidelines for minimal invasive autopsy or full-fledged virtual autopsy or all these guidelines are lacking. So institute to institute, the practice started varying and state to state it is varying. Many times we don't know what to do. And lack of institutional SOP. Many times there is no proper SOP in any mortuary. Only few mortuary or few autopsy room have developed the SOP, how to deal with infection, death, or how to deal with certain type of diseases or in any type of death, how to deal. So lack of SOP is also one of the hindering factor that we can or we have to improve it. No proper preparedness to deal with epidemic or we can say such type of disaster. It is one type of disaster in which so many bodies are coming in the mortuary. We have to, not for autopsy also, for preservation also. We have As we all know, most of the forensic people, those who are working in the government, they got the responsibility to manage the dead. They have to preserve in the cold room. They have to hand over. So handling of the dead body are on us. And neither that much body bag initially, neither there is availability of PPE kit at that time, because this is the first incidents we all got awake. All these things are required, and because of that, now most of the colleges are getting also all these things. As we can say, inadequate resources in the mortuary like body bag, gloves, PPE kit, instruments. So these are the things at that time. But now I think most of the mortuary, at least in the medical correct level, they come up all these things. They have enough now gloves, instruments, body bag, and everything. Before that, police is also not bringing. There is no concept that dead body should be brought in a body bag. You know, till it is not there in India. Many of the time they are bringing like that only. So difficulty in diagnosis in autopsy. When we don't know the pathogen, then during medical legal autopsy, or even though we conduct exclusively pathological autopsy, it is not possible many of the time to diagnose the pathogen, because we are dealing with the post-mortem blood chemistry. Many of the time we don't have the accurate data, and we don't have such type of laboratory who can assess the viral load and everything. So it is difficult. The concept of minimally invasive autopsy, even we know we don't have right now any strict guidelines on this. Even though few centers has already started virtual autopsy, we know that AIIMS Delhi has started, Nigrim Shillong has started, St. John in the Bangalore is doing. But do you have any proper guideline which is given by either Ministry of Health and Family Welfare or the given by the ICMR based on virtual autopsy? So that also we have to think upon. Now, what issue we encounter mainly in COVID is the infectious death autopsy, identification of dead body. Because the body is in the cold room in a body bag, and relative are also not going close to it to avoid the spread of infection. They will identify from far away, and which produce the mishandling of the dead body, exchange of dead body. Wrong dead body handed over to someone else, and they will take away far away distance, sometime up to the cremation, and then suddenly they will come to know this is not the body we want, this is someone else. So such type of issue came in the newspaper also, and that time also our department had some bad names. So we have to be very careful in developing such type of SOPs so we can fix the responsibility how such thing can happen. Even the right of last rituals in the infection in COVID, initially we say that no one should touch, no one will go nearby, and initially the corporation or the government, they are only disposing or cremating the bodies in certain state. They are not allowing relative to hand over or getting the handover of the dead body. So they are also deprived of that right of last rituals. Crematorial issues also, sometime in the crematorium also the staff is not willing to work, and many of the time community people are also not allowing. Humanitarian issue, we have seen few dead bodies in the river, they have been thrown in the river and floated, so which is also not the dignified way of management of the dead body. So we encountered humanitarian issue also in that, when we learn from that. So that is the lesson we learn from all these incidents. Then spreading of infection due to inadequate measures. Suppose sometime when the patient is admitted also, there's spillage and everything, we are not properly handled. Or if we talk about any new hospitals, when the hospital will start, they are not properly maintaining their STP or ETP plan. And many of the time the infected material are not being disposed of as per the biomedical waste guidelines. And it will directly go into the routine sewage and everything. This also creating sometime problem. Then one issue we encountered is decision making interference by authority. If I talk about Gujarat, when I was initially in the COVID time in Gujarat, we should not take any swab without the permission of that local collector. We have to send the forms, he will say then and then you have to take. So there is a inference by higher authorities also who are not of medical background, and all these things we have seen that. And whenever there is some issue like compensation allotted by the government, we find false cases also. Either death occur or some other person, they will falsely claim that he is also suffering, write down the cause of death as a COVID and everything. So all these things we have encountered, and these are the issues which we have faced, and we learned from that also. So if you see, these are the some newspaper highlights. Accidental body swapping, wrong ID tag at mortuary leads to swapping of the body in one area. Wrong body has been handed over. So we have to be very careful in this. Same way, if you see this accident, this Mukti Dham mein शब्द देखते ही बेटी बोली ये मेरे पिता ने. So body reach up to the cremation. Then relative came to know. So that is negligence on relative part also. So at the time of identifying, they have not properly identified. They have from far away, or sometimes they have not seen properly, and they took away the body. So this also create the issues. Even whenever such type of things are there, you find in India always corruptions is also coming up. So we find corruption in body bag purchase also. See, there is ex-mayor in the Mumbai, they is charged for the COVID body bag purchase scheme. So these are the issue when we hospitals are not getting enough body bag. We find this corruption issue which is really disheartening. That government is spending a lot of money, but it is not sometimes reaching up to the last point of that is the end users. So use came in purchase of body bag in Thrissur also. So all these are the things. So we have to be very careful. And in the hospital setup, we have to deal with. Sometimes we also face some allegations if we are working in the same. I will give you the example when I was working in Gujarat also. We are giving free PPE kit and everything to the ambulance driver, and relative will sit in the ambulance and they will go to the crematorium. And then we receive one complaint that ambulance driver was asking money from the relative, even though we make to understand the relatives that this PPE kit is free from the government, so you don't need to pay anything at the crematorium. Though such type of incidents were happen. So body bag disposal also, holiest river, as I told you in Ganga, we have seen the floated and it become international news and it gives bad name to the country. So we have to be very careful. Here also, Corona se mrut वृद्धा के अंतिम संस्कार का किया विरोध, किया हंगामा. So all these things happen at that time. Let's see some BNS and previous IPCs which are dealing with such type of spread of infection. So previously it was Indian Penal Code 269. Now it become Bharatiya Nyaya Sanhita BNS 271. So when any person negligently spread the infection of any disease. So here the word negligently is most important. It is not intentional, not with any motive. Negligently spread the infection of any disease, which has the probability to threaten the existence of human. Then there is a provision of imprisonment up to 6 months or with fine. So that is BNS 271. Furthermore is BNS 272. Previously it was IPC 270. So any act which has been done by a person with willingness or malignant intention. So here there is no negligent. 271 was negligent, here it is malignant. And person knew that such action would cause the infection to many people and ultimately would result in death. Then also such person has a 2 years imprisonment and fine. And such type of offense is cognizable but bailable and non-compoundable. So that we have to understand. So difference in 271 and 272 is the intention. Malicious intention is there in 272. So we can say it is a mens rea, criminal mind is there. So that's why punishment is also more. 6 months and here it is 2 years. Now if we see BNS 273, previously in IPC it was 271, disobedience of quarantine rule. If you are forced to quarantine, if you are suffering from some infection, that if you go out in a community and spread it, then you have to remain in a quarantine. If you disobedience of this rule leads to 6 month imprisonment or fine or both. So this is the certain law provisions present in the BNS related to the spread of infection if we don't take proper precautions. Same happen in the autopsy room also. If we are not giving proper PPE kit to our assistant or we are not having proper biosafety level autopsy, and because of that if someone claim and go to the court because of this center the infection is spreading or it causing harm or death, then we have to be very careful. We see the previous judgment also, old judgment in old time in British era. You can see 1886, the Madras High Court at that time given order to catch all the person who despite of being affected by cholera traveling through train. So you see at that time also the court has given certain judgments. Even in 1902 also, person traveling by train and he stayed in a area where there was a plague. So at that time also they have given the judgment. Okay, the person may acquire the plague infection because he stayed in that area and why he is traveling in a public transport. So all these things are there. So we have to be careful. Now we see the biosafety level. So this table I found is very important on this. If we see the one column is the biosafety level 1, 2, 3 and 4 type of infrastructure. Then which are the agents, what type of practices we have to follow and which type of biosafety cabinet should use and what we have to be careful. So if we see we know the agent, infective agent we know, and we know that this agent is not known to cause any disease to the healthy individual. Then you can just follow the standard microbiological practices, wear gloves and everything while doing the autopsy. No such specific biosafety cabinets are required, and you can do by open bench and sink that we are doing all one. So all autopsy, we can say autopsy room are biosafety level 1 compliance. They are there. We have sink facility, we are wearing gloves and everything. Hardly at few institute, few servants are not wearing the gloves. Otherwise, we find all are dissecting the body with wearing gloves only. If we see the biosafety level, means other agents which has associated with human disease and which has a route of transmission include percutaneous injury or by ingestion or come in contact with the mucous membrane. Then we have to use biosafety level 2 type of level, in which biosafety level 1 plus limited access to the public. We have to display the biohazard warning sign. We have to take sharp precautions. biosafety manual we have to follow, and follow the waste decontamination process also, medical surveillance also. So here we can use class 1 or class 2 biosafety cabinets or other physical containment devices. Even we recommended to use the PPE kit. So we can see, before COVID, I don't think so any mortuary are getting enough amount of PPE kit, and they are conducting autopsy on dead body in which we don't know which type of infection is present. And sometimes we know the infection, either it is HIV or TB, either they are getting enough amount of PPE kit. So these are the questions. And we should have facility of autoclave, whatever the instruments we are using in this, we have to do it. Then if we go further, if the pathogen is indigenous or exotic in agent, with potential for aerosol transmission. So here transmission occur by aerosols, and which may produce lethal consequences by spreading the disease. Then you can use the BSL level 3, which is BSL 2 plus certain other things, controlled access, decontamination of all waste, decontamination of laboratory clothing before giving for laundry. And if we see again biosafety cabinet class 1 or class 2 and other containment devices, PPE kit we have to use, as well as the respiratory precautions we have to use, because here it is transmitted by the aerosols. So here also physical separation should be there from the common access corridor. So it should be separate. That should have a self-closing, double door access. Now we see self-closing doors are there in the PGI Chandigarh mortuary. They have sensor-based door. I think all of us has seen that video. An exhaust air is not recommended, and we have to apply the negative airflow. So again, negative airflow only few, like PGI Chandigarh has developed few 1 or 2 rooms with negative chamber. AIMS Patna have negative chamber autopsy. So all these things we have to create now. And the last one is the dangerous or exotic agents which has a high risk of life-threatening disease transmitted by aerosol. So in this we require biosafety level 4. So it is biosafety level 3 basic requirement, plus clothing should be required before exiting. We have to take showers. All material need to be decontaminated. If we see that we have to take primary barriers, biosafety cabinet class 3 should be used. And positive pressure ventilation is required. So if we see that also we require separate building, isolated zone, dedicated supply of vacuum and decontamination. So all these things is required. Many of the time as a forensic personnel, we are also not aware which type of biosafety level room is required and which type of equipment is required, how to procure it, how to maintain it. So that is also one type of administrative challenge to establish as well as maintain. Now, if we see whenever we are conducting autopsy, there may be a various sources of infection, but basically by 4 sources, we can come in contact with the infection. One is the blood or any other body fluid, either it is saliva or pleural fluid or any other fluid comes in contact whenever we are dissecting. Sometimes waste product, feces or urine. This is less chance to, but urine and stool can be also considered. Then aerosol of the infectious material. Sometimes we opening the body or sometimes spreading, spurting. It may also cause the thing. And skin, direct contact with the skin. If the blood or body fluid of the disease come in contact with the skin or some wound we have, then also it produces the direct transmission. So how the infection will occur to the autopsy surgeon or any other person who are assisting. Suppose you put the contaminated finger, you don't know, hand or finger in your mouth or nose or eyes, then it may spread. Breathing in a aerosols environment, small infection droplets are there which are not visible by naked eye. If you breathe in such atmosphere also, it will spread the infection if the disease is transmitted through aerosols. Splashes of blood or any other body fluid into your eye or mucous membrane or nose or mouth. These happen usually in the treating patient when they are doing tracheostomy or something. Sometimes splashes will occur into eye and they will acquire the infection, treating person. Sometimes broken skin, we have any broken skin or infected wound which is in direct contact with the microorganism. Or during autopsy, we are handling sharp edge equipments and we have that skin penetrating injury. If we are not dissecting properly, we may get injured by the knife itself. Or sometimes broken rib edge, when we are cutting the ribs, they are broken. When we are inserting our hand into the chest cavity, sometimes we get injured. So how to prevent this? So many international guidelines are telling that those persons who have a reduced immunity, don't subject them to the such type of hazardous work. Second thing, vaccination, or all staff who are working with such type of environment, they must be vaccinated, at least for hepatitis A, B, measles, mumps, rubella, varicella, diphtheria, tetanus, pertussis, polio. So all this vaccine is there and they have to take the time to time booster dose depending upon the vaccination. And whatever immunization you have or you are protective, but you should apply the additional precautions. It's not like that I am fully vaccinated, my immunity is strong, so I will do whatever you want. No, we have to take precautions as and when depending upon the pathogens. And if we don't know the pathogens, at least we have a PPE kit Now, if we see the USA and other things, they have infection control nurse also. And whatever we find pathogens, we have to notify. Here also we have a notifiable disease, list of notifiable disease. So if your pathogen is there COVID, then it is notifiable disease. You have to notify. Suppose you have some viral fever, which is notifiable, then you have to notify. And we should not hesitate while using the body bag. Now, actually, COVID given us this opportunity that we have to use the body bag in each and every death, because it sometimes prevent the infection as well as spillage and leakage of the body fluid also. Many of the time we are not using, or many centers are still not using. For COVID time they have used, then they are not using. So better to use body bag, because relative are also transferring the body sometime far away distance, 10 kilometer, 20 kilometer, 100 kilometer. So if body is in body bag, then it prevent the leakage of fluid. Now family at risk, because if you know different culture, different cultural practice with the dead body. Sometimes we wash the body, sometimes we put some water, tulsi pan, or many other religious beliefs are also there. So depending upon the pathogens, they have also given the requirements or recommendations what we have to do. That we will see depending upon the pathogens what we have to do. So we can educate the family at that time. Okay, this is the disease, so these many things are allowed and these many things are not allowed. So they have an idea. But many of the time we are not giving any education to the family. We just finish the postmortem, then we start preparing our report, and body is handed over by the servant, mortuary technicians, and they don't know, and they will just hand over. So be vigilant in the infection death to educate the family. And what are the guidelines for preparation of the body depending upon the infection they suffer. So if we see, there is one classification in which they classify according to the risk. So if we see very high risk diseases, these are the anthrax, Lassa virus, Ebola virus, yellow fever, plague, rabies, SARS, or septicemia due to the streptococcal group A infections, smallpox. So all these are very high risk disease. They have classified. So if the dead body is suffering from such disease, then body bag is must. We have to use the body bag. Viewing and touching is prohibited. We must instruct the relative that try to avoid the touching the body. No embalming. Embalming should not be done. Whatever hygienic preparation, body washing and everything should be banned. And airborne precaution must be taken by each and every person who are in or near contact of the body. Cover your face with face mask, as well as the avoid all the portals of secretions that can come in contact with you. So this is recommended for very high risk diseases. Let's see the lower category, high risk disease. So these are the transmissible form: encephalopathies, typhus fever, hepatitis B, C, hepatitis D, HIV or AIDS, or any other disease in which there is a seepage of body fluid. So this we can consider as a risk disease. Here also we have to use body bag. It is must, because usually in transmissible spongiform encephalopathies it is must, and also considered for other disease where there is a leakage of body fluid. Otherwise, you can not using body bag, then it's okay, but try to use as far as possible. Second thing also, embalming should not be done. Don't embalm such bodies. Warn for the potential infection risk. Ritual washing or preparation of the body should be done, but under the supervision and advice of the use of standard precautions. Now, once hand over the body, we don't know whether relatives are using that standard precautions or not. They are understanding what standard precautions or not. So these are the risks they have to take, and again they have cover the face with mask and all the bottles of cigarettes. Now let's see the medium risk diseases: cholera, diphtheria, meningococcal disease, methicillin-resistant Staphylococcus aureus, typhoid, paratyphoid fever, relapsing fever, scarlet fever, TB. TB they are considering in the medium risk, and we know it is more common in Indian community. Many of the time we are doing post-mortem of any unknown people or beggar, or sometime people suffering from TB from the lung. We come to brucellosis, salmonellosis, vancomycin-resistant enterococci. So these are they have listed in the medium risk. Medium risk also body bag is advised to prevent the leakage of body fluid. Now, if I can recall my days also in TB, how many days we are giving in body bag, because at that time there was no much concept. Hygienic preparation of the body is permitted with appropriate precautions. So this also we are many times not advising to the relatives. Viewing and touching is allowed as appropriate precaution is taken. Then you can. Embalming is also allowed possible. Contact need to be taken. If there are excess secretion, then adopt the droplet precautions. Avoid the splashes, aerosol, and particles, and cover your face of your as well as the cadaver with face mask, so any portal of secretion will not come out. Now, low risk. Any other infection, they are coming under the low risk. In low risk, body bag is not required. Hygienic preparation is permitted. body can be handled, view, touching, everything is possible, embalming can be carried out. Even if we are sometimes don't know either the infection is present or not. He may be suffering from HIV, TB, hepatitis B, or sometime TB. So it is always advisable to use the standard precautions whenever we are handling the dead body. So these are the tables I found in various literatures. Like cholera, then PPE kit is required, Ebola virus it is required, Congo fever it is required, Lassa fever it is required, influenza it is required, PPE kit, then body bag also where it is required, where it is not required. So all these things are there. So we have to go some detail in the microbiology and came to know how we have to handle all these infections. Then pathological autopsy. Now I think if we say pathology is the main branch, initially if we see recall the history, pathology was combined with the microbiology, it was a common subject. Then microbiology got separated from pathology. Then from pathology, ISBT was separated, immunohistomolecular transfusion. And initially I can see 280s and pathologists are doing autopsy, both type of autopsy, that is pathological or medical. Then forensic medicine developed and medical legal autopsy handled by us. But still few institutes are practicing pathological autopsy. But most of the institute have stopped the pathological autopsy, which is very important way to learn also. So whenever an institute is following pathological autopsy, where the medical legal requirement is not there, sometimes forensic person is not involved also. Only pathology people are dealing with the pathological autopsy. I can recall PGI Chandigarh doing, AEM Hospital, Mumbai doing, and many other institutes are doing regularly pathological autopsy. But sometimes they are not taking proper consent, not maintaining proper registers. So that also we have to be very careful. That we have to take proper consent from the next of the kin regarding the autopsy, regarding the preservation of organ, removal of organ, examination, retention, and disposal of organ in a proper biomedical waste management rules, and not using such organ for any other purpose. If you are using for research, then you have to take consent for that also, but not any other purpose, like not for organ transplantation or anything else. Clear? So that explicit consent we have to take, which is a common practice in the Western countries. But here we find sometimes that consent is not appropriate and they are not maintaining register also properly. So if we see the hazards, mainly we can see as a doctor we are using most of the time and we have knowledge also. But we have to educate our autopsy workers also, that they also take the proper standard precautions whenever they are handling the cadavers. And one thing we have to remember, that all cadavers should be treated as a potentially infectious, regardless of their non-infectious state, because we don't know, we have not detected, or means clinicians has not detected proper test. All the fluid and tissue specimens we have to consider as a potential infectious source. So be careful while handling that. Whenever we are doing postmortem, wear the complete protective wear to save yourself as well as your other colleagues also wear the same things. Whatever the instrument we are using, we have to decontaminate properly. Use chemical germicide in a proper way so that we can kill the germs. Whatever specimen we are collecting, that we have to put in a well-constructed container with a proper secure lid, so it prevents the leakage in the transport. Because we know that we are also preserving viscera for forensic science laboratory, which is handled later on by police officers who are not that much educated. They don't know how to handle. So whatever training or something we will give, but there is always a risk that a person may have needle stick injury or any other occupational injury. So if we see the ratio, certain studies done by the Western country, that while performing the autopsy, there is a 1 in 11 autopsy performed by resident, there is a chance of needle stick injury, and 1 in 2 autopsy performed by staff pathologist also. So there is always possibility you may miss sometime in a speed or sometime haywire, you may have get injury. So injury mostly occur on the hand, usually on the thumb or index finger, middle finger, which is our dominant hand, or the other hand. We'll get mostly injured. Sometimes dissected rib, as I told you, sharp edge will also produce injury. So we have to be careful. So in this, what a take-home message we can say is first of all, we have to develop the appropriate infrastructure. So whatever setup we are working, I think we all are working in medical colleges. And medical colleges now, autopsy rooms are, I can say, last 10 years or 15 years. Most of the state has renovated their autopsy infrastructure. But if possible, we can create negative pressure chambers or try to develop some more biosafety levels. Second thing, make sure that availability of gloves, PPE kit should be there to all the persons who are handling the body. We start forming the SOPs, how to deal with the infectious body or how to deal with the disaster also. So if we frame the SOP as per the convenience of our institute, then it will be good. We have to arrange regular training So we will update it, which type of pathogens are there, how to deal with that pathogen, even what type of material need to be preserved, where this material will get detected. Many of the time we don't know, okay, this is the virus, which tissue need to be preserved, what should be the preservative. Now after this, such type of viruses detected there. So protective material diagnostic capacity also we have to improve, and we should not forget to give the humanitarian approach. We know that we have to deal that body in a dignified way. So humanitarian forensic is also one of the important aspect that we should not forget. So these all were my references from which I have taken all this material. And thank you everyone for gentle listening.
Thank you, Dr. Pragnesh. So this is a very important topic. We all know that whenever we are dealing with the postmortem of infectious body, we are at a great risk. Even I know when I was doing post-graduation, so we conducted one autopsy, and my co-PG got a cut on the finger, and later on we came to know that that body was HIV positive. So he had to take the post-exposure prophylaxis. So thank you, Dr. Pragnesh, for telling in detail that how to prevent this and what are the guidelines to be followed. So thank you, Dr. Pragnesh. Thank you.
Thank you everyone for gentle
Thank you very much. So now we will have a lunch break. After that break, there is one session by me, and then we have a poster session by PG student of AIMS and students of Adesh, and then we will have a GBM. Okay. Thank you. Now we'll break for lunch. Thank you.